Any remarks? Do we have any apologies?
Unfortunately, Tempus is not here today, Chairperson. It is me, Tepo Mori. I have not received any apologies.
Thank you, Tepo, for holding the fort. Welcome. Thank you, colleagues. Colleagues, it's just now 2 minutes past 10. I just want to immediately start our meeting. Today's meeting is really to focus on two issues. Members just reflecting, making your own reflections on the hearings we have had so far, and also comments and contribution about our program, if there are amendments needed and improvements in that regard. We will also have an opportunity to have our legal services perhaps just giving us a very brief reflections on the correspondence we have received from Advocate Public Protector Mkhwebana's attorneys, which would have been raised in the meeting yesterday. I will allow Fatima Ibrahim to say one or two things in that regard. I hope you have received the letters sent to you in that regard. And so, in appreciating your attendance, colleagues, we're meeting today for the 8th consecutive day being together. We had 7 consecutive days of hearing until yesterday. And I will hear from you when you make your own reflections and remarks. But I do need to say that your contributions and guidance is well appreciated in handling a very important, complex matter for the National Assembly. Hope that you would have been part of starting that important historical journey. But it's very clear that a week later, there might be a few things that we must attend, tighten up, or relook or rethink about. I just wanted, as part of my remarks, to say at least one or two things that I would have promised to say. Yesterday, I had promised Advocate Mpofu that I would make a point about the issue raised last week about double jeopardy. And I held back because I thought, let me hold that back and share that with you first, so that post this meeting, that becomes part of our journey. Advocate Mpofu would have raised consistently so the issue of double jeopardy in relation to Public Protector Busiwe Mkhwebane. I want to draw your attention, colleagues, to the supreme law of the Republic, the Constitution, to Section 35 in that Constitution. Section 35 is the longest of the sections you would have in the Constitution. It runs to about 2 up to 3, close to 3 pages. Section 35 deals with the arrested, detained, and accused persons. That's what that section is about in terms of their rights and everything else. But I want to draw you to, in that section, to Section 3, M of that section. And for completeness sake, I will read it. And it reads that not to be tried for an offense in respect of an act or omission for which that person has previously been acquitted or convicted. So these are the rights of accused persons, someone facing criminal charges in the proceedings to determine criminality liability. And they concern with multiple processes of either acquitting or convicting. And the key points to be made in this regard is that the PP is not at risk of double jeopardy, because these are not criminal proceedings or civil proceedings or judicial proceedings. What we are about, what we have started, what we're in the middle of, these are constitutional proceedings that the Constitution prescribes only to the National Assembly. And us being members of that National Assembly in this committee, that has been prescribed to us to discharge. So there is no possibility that the committee that we are, or Parliament, can make a finding on civil or criminal liability. Neither the committee nor Parliament can send her to jail for a criminal offense or require her to pay damages for civil liability. So there's no risk that Parliament will risk duplicating the determinations that a future criminal court may make, or risk exposing the public protector to 2 criminal sanctions for the same criminal conduct. So it is important to make that point. But I think the last key points, therefore, that one wants to make is that the PP's rights under Section 35(3)(m) that I've just read to you of the Constitution have not been triggered. She is not an accused person in front of this committee. Now, that cannot be clearer than that, coming straight from our supreme law, from the Constitution. And I think the legal rep of the public protector has been very consistent in trying to put this matter and saying that we are exposing her to double jeopardy. That's one important point that I thought I wanted to deposit as I invite you to make your own reflections about what you would have observed, what your concerns are, where do you think we need to improve and tighten, and also when we resume on Wednesday next week, because some of these are also going to have to include the program that initially we agreed that end of September is our timeline. And with 5 days that have been put aside, it's very clear that we're likely to have to relook and review and amend or improve that program. It's going to take a bit of sacrifice additionally to all of us to achieve this. So far, I think I've been making the comments publicly that I have not been alarmed to think that we're out of track. I still remain confident that we're on track in terms of our process. Yes, there are challenges, and with your guidance as members, I've been able to draw a lot from your own contributions and so on. Thank you very much, colleagues. I'm going to invite you to make your own reflections and comments. I see the hand of Honorable Melder.
Thank you, Chairperson. Good morning, colleagues. If I may say, Chairperson, I 100% agree with your interpretation of this whole issue with regard to double jeopardy and the constitutional provision. I think that's absolutely correct. I just want to make one point. In your explanation that you gave just now, I don't know I can't remember the exact wording, but in the intro, at some stage you referred to the public protector cannot be charged again for a crime, etc., something in that vein. I know that is what you meant was obviously to say any alleged contravention or any alleged crime or whatever the case may be. I know that is what you mean, because I just don't want somebody somewhere to misquote the chair or the committee. Thank you, Chairperson.
Thank you, Honorable Melder, for that redirection. Thank you very much. As Chairperson stands directed there, I appreciate that. I now recognize Honorable Hendricks to be followed by Mr. Honorable Milham. Why did I call you Mike Milham? You seem to be Kevin here today. Have you changed your name? So you are recognized after Honorable Hendricks, followed by Honorable Van Minen, followed by Honorable Heron, in that order.
Thank you very much, Honorable Chair. Honorable Chair, I'm sure that you won't have a quarrel if we go beyond just talking about double jeopardy, if I understand you correctly. First of all, Chair, I would like to thank you for your leadership over the past few days. You held back at the beginning, but later on you speeded up things. So we won't be here until Jesus comes home. So thank you very much for that, Honorable Chair. Honorable Chair, I would like to comment on something that has been raised repeatedly, and that is the expert witness. Mr. Ibrahim, for me, was an expert witness because he put into context that, as members of this committee, Parliament comes first, not our political party. And there were actually signs of such noble conduct. And I'm sure we will see more of that. Even Dr. Mulder was recognized by the advocate as moving in that direction with his famous 6 questions, or 7 that he raised. However, the expert witness, there was a shortfall. Maybe we expected too much from the expert witness. We expected the expert witness to focus on what I call alternative dispute resolution, because as you know, Honorable Chair, that the core of the Office of the Public Protector in Al Zama's view, and the personality of the Public Protector got her the job. And that is doing the extraordinary. Now, I would like to clarify that and maybe think about what happens at the CCMA, which is an excellent example of an alternative dispute resolution. But in this particular case, you find that this flexibility, this opportunity to do things like out of the norm is counterbalanced by the fact that there is direct access to the High Court, which is not necessarily the case in the CCMA. And so that is a nice balancing act that will satisfy, those of us that are very impressed with Roman law, Dutch law, Afrikaans law, Latin terms, which I personally feel that is not right for an inquiry of this nature. It must be balanced by African common law, African jurisprudence, and so on. Something that's getting traction in our country now, that we feel that one should have a people's parliament, a people's constitutional court. So why can't our inquiry set an example and be a people's inquiry? So that is my concern, that maybe we should look at bringing in an expert on, and I did write to the committee about this very early, that can tell us about alternative dispute resolution, the risks involved, and we know that the Public Protector took many risks. But in conclusion, Honorable Chair, I think the point came out very clearly yesterday that the Public Protector, is not a one-woman show. We must stop talking about one-man shows. It's not a one-woman show. And there's so many people involved, and the Public Protector, while the buck stops with her and before she signs, so many people are involved, and she raises concerns, even with other experts. Look at this, look at that. So we are, and this I mentioned earlier, and this committee must not destroy the office of a Public Protector. It must allow that flexibility to continue. We must not let the office of the Public Protector become like a High Court or a constitutional court, because Advocate Bauer made a very important point, that the Public Protector's Office is there to serve the poorest of the poor. And I gave an example in Massapumbelele where I told the Public Protector, take off your high heels and put on gumboots when she walked through the sewerage to address the plight of the African child living in sewerage in the far south near the Salmon Sound Naval Base. So in reflecting on what has happened, I am a bit concerned, that Parliament has overreached itself, that it gave directives and terms of reference to this committee, I think, to match the American system of Senate inquiries and so on. This is not a Senate inquiry where they're trying to nail Trump for causing the unrest at the end of when he lost the elections. This is supposed to be a people's inquiry. The expert panel had no people on it. He only had experts. We need people on these inquiries, and honorable members represent the people. So that is a good start. But that expert inquiry that told us to follow this vigorous and rigorous procedure, there were no people. It wasn't a people's inquiry. It was an expert inquiry. I would have imagined that Advocate Bauer mentioned that we are here to discuss 4 complaints that the Public Protector is not fit for office. So the motion was tabled by the DA. Shouldn't they have come forward and presented their version to show that the Public Protector is not fit for office? Why must Parliament do the dirty work of a political party? I think that's not right. It should have been I know Parliament eventually approved the motion, but the political party that proposed the motion, surely they must be in the forefront and say this is our version. And then we would have expected the Public Protector to say,
to wrap up, please wrap up now.
Yeah. We would have expected the Public Protector to say, this is my version. And the committee based its findings on the 2 versions. Not this, the way we're going is we want to set standards higher than the Constitutional Court. Thank you very much, Honorable Chair.
Thank you, Honorable Hendricks. Honorable Mayam.
Thank you, Chairperson. And Chairperson, it's always been Kevin. Michael is my uncle who has passed away several years ago. So I've always been Kevin.
Thank you. My apology for calling you Michael.
No problem at all. Chairperson, I want to address you on the way that the hearing has been conducted. And I'm not criticizing you in the slightest, but I do have a couple of concerns. The first concern I have relates to Rule 5.9 or Directive 5.9, and specifically the way that that has been implemented. I'm concerned that the directive reads, and if I may just read it to you, it says at 5.9, a member of the committee, either directly or through the evidence leaders, may ask Advocate Mkhwebane directly to respond to certain questions posed orally or in writing, including factual disputes that may arise, even if she is not at that time giving evidence. Then it goes on. Advocate Mkhwebane must respond to such questions immediately unless she requests a reasonable time within which to submit a response. And then it goes on to give the chairperson the authority to determine that. Chairperson, my concern here is that when you pose a question for a reply, if it is within the witness or the public protector's immediate knowledge, in other words, if I ask her, are Sianago attorneys your private attorneys, or are they the attorneys of the Office of the Public Protector? That's something that she has immediate knowledge about. I would suggest, Chair, that it's only where she doesn't have the immediate knowledge. In other words, where she has to go and look something up or find information or whatever it might be, that she should be permitted to come back with a written response. I don't believe it serves the interests of this inquiry or the interests of justice and fair procedure to allow her to take 7 days on even the simplest of questions. So, Chair, that's the first issue that I wish to raise with you. The second, also in the directives, goes to the manner in which several situations played out during the questioning of the witnesses. So the first is with relation to 6.2, which reads Directive 6.2, all questions put to any witness, whether by the evidence leaders or any member or the public protector, shall have due regard to that witness' right to human dignity. No witness shall be subjected to questions and or statements that bully, intimidate, harass, gratuitously embarrass and or deliberately insult the witness. Chairperson, I want to put it on record that during the cross-examination, first of all, of Mr. van Lochrenberg, his medical status was made public for all to see. And secondly, during the cross-examination of Mr. Kekana, there were some really, really horrible insults that were hurled at Mr. Kekana, to the extent that he was called a liar, he was called dishonest, it was absolutely untenable what was said to that. 6.3 also notes that no person, while questioning a witness, shall impugn the character of that witness. And I think that this goes further to what I'm saying here. Chair, then my last point is with regard to repetition. At several times during the cross-examination, Advocate Mpofu put questions to the witness that had already been answered or had been answered in a slightly different format, but he was looking for a specific answer. And I don't believe that is fair, and I don't believe it serves the interests of this inquiry. I think that once a question has been put, we must move on. And so here I'm specifically referring to Directive
6.4.
6.4, yes. Yes. And Chair, I think that this is something that we need to take a firmer grasp on in the hearing, that the repetition of a line of questioning ad nauseum only serves to delay the proceedings and draw out what could have been concluded in one day to several days of cross-examination. Lastly, Chair, I think that we also need to look at some of the relevance of questioning. There's certain, I want to call them rabbit holes that we go down in the line of questioning that don't address the issues that are before us. And that is whether or not the public protector is fit to hold office, and or whether or not there has been misconduct in her actions. And so I think we need to ensure that the line of questioning leads us in that direction rather than in some spurious direction that tends to distract or muddy the waters. Thank you, Chair.
Thank you, Honorable Kevin Milam. And I recognize Honorable Benedicta van Minen.
Thank you very much, Chair. I must say I have, to a large extent, been covered by the Honourable Milam. I am concerned, and I think that this possibly goes to the root of the problem. This is a parliamentary committee. We are acting in terms of our mandate. Our mandate is, in fact, very clear. But I think that there are certain individuals who possibly are not entirely familiar with the format and who, by virtue of their legal training, are trying to push it into more of a trial proceeding. And I think some of the difficulties with the directives come from that sort of push and pull. This is not a trial. That has been made very clear. However, obviously we are guided by the South African legal system, by South African law, by the body of the legislation, constitution, etc. In that regard, the first witness as a expert witness is a very specific kind of witness who comes to give very specific kinds of information. And I think it's unfortunate that that wasn't contextualized before he started to give evidence. But our mandate is very clear. And I think it is important, in order to ensure that mandate is properly carried out, and I mean that is contained in the last line of section 5.9, where it talks about the committee being able to properly fulfill its mandate and carry out its oversight function, we really do need to enforce the directives better. I think that the line of questioning at times has been extremely adversarial rather than inquisitorial. There have been comments hurled around and made that are unfortunate. And look, we live within a public context. This is something that is being televised live. The whole nation can see it. And one needs to bear in mind that this is not a jury system. This is not a popular system. This is a committee of parliament that will be making certain recommendations. And I think we need to narrow the focus to remember that it is the people who are here who are the ones who are actually overseeing the entire process. And in fact, in answer to the Honourable Hendricks, what we're actually doing is protecting the Office of the Public Protector, because that office is there to perform a very important function for all South Africans. And we have to be sure that the person who is there is a fit and proper person within the requirements thereof. So an inquiry like this is something that is very important. It's very important to the people of South Africa. But I really want to appeal to you, Chair, to be very firm with the directives. The constant questioning of the directives after they've already been accepted, the second guessing, the constant appeals to change and to amend and to alter them are not good for this exercise. And I really would appeal to you to ensure that we are very firm and we actually proceed with it so that we are able to fulfill our function. Because at the moment, there are times when it really does become more about theatrics than it does about actually carrying out our role. Thank you.
Thank you, Honorable Van Minen. And I recognize Honorable Heron.
Thank you, Chairperson. Chairperson, I have a number of issues just on the double jeopardy. I agree with you that I don't think the rule of double jeopardy applies in this instance. So we can, I'm not going to say much more on that. I think that we do need to look at the Directive 5.9 again. I mean, I used it on Friday and I wanted to use it yesterday, but I did become concerned that we are raising questions using Rule 5.9 and accumulating a pile of questions for the Public Protector before she gives evidence. And some of those questions, most of them, all of them, in fact, that I would have asked, could be posed directly to the Public Protector in response to her evidence. And maybe 5.9 is going to create a huge pile of blockage for us because on Friday, one or two questions ended up being incomplete and 10 or 15 questions. So I think that we must look at Directive 5.9 again. And if the Public Protector is going to give evidence, then our opportunity to raise the questions that arise out of the evidence of these witnesses that have appeared so far is presented when she gives evidence. I do also want to raise the question that was raised when the directives were first put before the committee, when we were sitting as a committee hearing evidence. I think that was on the first or second day before they were adopted. And the Public Protector's team raised the question around whether we're going to follow a narrow approach or a broad approach. And by that they meant, were we going to pursue elements of the evidence that was used in support of the charges where the independent panel found that there was no prima facie evidence to support that evidence. So I think that we need to discuss that because the legal advisor said, well, we have to follow the motion. But I think the committee can decide that we do not need to call evidence that has already been assessed at some level by a judge and two senior counsel as lacking any prima facie basis. And so maybe we should narrow our focus to those issues that the independent panel have identified as providing prima facie evidence of misconduct or incompetence, and not include evidence that has already been adjudicated and found perhaps not to be relevant. Just on the issues or the points made about the questions to witnesses, I think that we have to remind ourselves that the public protector is being accused of very serious misconduct, of breaching the Constitution, of committing misconduct, and of being incompetent. And these charges are open to being tested. I mean, the point of the public protector being present, the point of audi autem partem, is to test the evidence of witnesses who say, who give evidence against her. And I don't think we must be overly sensitive as members of the committee to the fact that the evidence of witnesses is being tested vigorously. If I was representing the public protector, I would do the same thing, test the evidence as vigorously as I can based on the evidence that I'm going to bring. So witnesses who provide affidavits or give evidence even under subpoena, I think should expect cross-examination, and cross-examination is not easy, but it is a legitimate process. And so I don't think we must be overly sensitive that the witnesses are being vigorously cross-examined. And then finally, although I agree with Honorable Van Minden that this is not a trial, as I said earlier, I mean, what we're doing now is hearing evidence of misconduct and incompetence. And in terms of the terms of reference, our role is to make a recommendation to the National Assembly as to whether that evidence is sustained or not, or those allegations are sustained or not. So the process has a even though it's not a court, it has a kind of trial or disciplinary hearing style to it. And so I don't know how the process could be conducted in any other way if it is going to be a fair process without the opportunity for the witnesses to be cross-examined, and then for members to ask questions thereafter. So I'll leave it there. Thank you.
Thank you, Honorable Heron. I now recognize Honorable Sukas.
Thank you, Chair. Thank you, Chair. I just want to raise two issues, and it is the issue of fairness that I want to raise, that it should be the guiding principle. I think we all agree, and it has been stated here again, that this is an experimental process, a novel process. And I would want to add that I think Honorable Hendricks mentioned that, you know, we cannot use the American system, but I just want to say that in the US, in over 200 years, they only had 4 impeachments, which shows you how novel and experimental this process is even for us. So when it comes to the question of fairness, we should, I just want to say it should be the guiding principle, and it should be 3 ways fairness. It is firstly to the public protector, and then secondly to the witnesses, and then to the people of South Africa. Honorable Hendricks mentioned that the cost of this process is about $1 million a day. Now, I don't know if that is accurate, but if we only had 10% of that money go towards child welfare centers, it would make a huge difference. So the effectiveness of the Office of the Public Protector is very important, because the public protector ensure billions are better spent. So fairness of process to the people of South Africa requires that we ensure the suitability of the public protector, efficiency of the office, and that necessary changes be made to strengthen the office. I will come to this later, but these are the issues that I think should be on the agenda as well. It is a novel process, and we must ensure fairness, and we should be willing to amend the rules where necessary, especially as we had a week to see how the process is developing, Chair. So in a key component of ensuring fairness to the people, as noted by Honorable Hendricks, is that the process must move forward and we do not overrun our program any more than what we need to. And this committee should therefore meet regularly, Chair, to discuss how to keep the process on track. Our rules should support this goal, I would say. And I also, Chair, want to address fairness to witnesses as well as to the public protector. Fairness to witnesses should be part of our agenda. And we need to deal with this first because yesterday, Mr. Kekana was very reluctant, and understandably so, to venture into areas that could impact his career and his livelihood. Now, and I think we should be sensitive to those things, you know. While his testimony would be protected in a court, he may have needed legal advice, as there are many other places that his testimony could be used, not just in the courts. So I would have wanted, if I was Mr. Kekana, I would have wanted legal advice. And I believe he should have been allowed advice either by being allowed to answer in writing or by some other mechanism. And so, Chair, I think, Chair, we should have a set of criteria to decide if he can either, Chair should compel a witness to answer or allow the witness to then answer in writing, or for the witness to consult with counsel. I do appreciate, like Honorable Heron has said, and I must say to my colleagues that I really appreciate that we have all the different committee members with different experiences. It certainly is a huge learning opportunity as well. It enriches the experience of the committee. I appreciate what is mentioned here in terms of the public protector and the risk that she faced. But the witnesses needs protection as well. There is an element of risk to them as well. The public protector has the protection of a very well-known counsel. She has the opportunity to answer in writing after careful reflection and without pressure, and a counsel at input into the rules. So something the witnesses have not had. So when I speak of fairness, I speak with it within that context. And then I also have sympathy with the issue that that the public protector need to answer questions in writing, and that it may be unfair to the public protector. There are pros and cons that I believe in terms of that needs to be addressed. I only want to add, Chair, when the public protector gives evidence in chief through the Chair, that there be a set of criteria to decide if Chair can either compel her to answer immediately or allow for her to answer or to consult with her counsel first. And then lastly, Chair, I just want to add to what Honorable Van Binnen has said. We cannot forget where the hearing is happening. It is happening within Parliament. The witnesses that are coming forward are coming to address Parliament, in essence. And therefore, for me, the issue around the mental illness, the whiskey, all of those kind of things, we can never forget that they are within Parliament, not within a court of law. And we cannot violate the basic rights of South Africans when they are addressing People's Parliament. That is just what I want to end off with, Chair. Thank you.
Thank you, Honorable Sukas, Honorable Dlakude. And then after you, I will note Honorable Vuyozungula, followed by Honorable Kijimanis Kosana.
Thank you very much, Honorable Chairperson. Good morning, colleagues and everyone on this platform. Honorable Chairperson, thanks for this opportunity. I want to agree fully with you on your quotation of the Constitution, Section 35, based on that issue of double jeopardy. You quoted it very well, so I'm not going to repeat that. Thank you very much. Then I want to also take us a little bit back to say that this is the Committee of Parliament established based on the Constitution Section 194 and also through the resolution of the National Assembly. We have our terms and references, which we adopted in the National Assembly. And our activities as a committee is guided by the rules of the National Assembly. So I want also to re-emphasize the fact that as this committee, we don't have a predetermined outcome. Ours is to embark on a fact-finding mission. We haven't found anyone guilty of anything. We don't have all the facts. So what we are dealing with here is the evidence that is being brought to us by those witnesses and those who are still coming. We haven't come to any conclusion. We haven't also dealt with the issue of whether the evidence by this witness is true or not. We haven't come to that. We are still listening to the evidence based on the witnesses presenting themselves. So I want to believe, Honorable Chairperson, that this process is also a public process, because there was an advert by Parliament to invite the public to participate. Hence, we have the witnesses that we are having. They have deposited their affidavits to this committee so that they are willing, and also some will be subpoenaed to come and assist this process of Parliament. Indeed, it's a process of Parliament. We don't have any hidden agenda. And it is, yes, it is for the first time that we are dealing with this Section 194 process. But in the past, we have dealt with other constitutional processes as Parliament, and we are still going to do so. So I want to say, Honorable Chair, the program of this committee, as well as the directives, these are living documents which we must always try to improve as we move on. We must also, Honorable Chair, through the assistance of our, what do we call them? Our evidence leaders, intervene where there is a need. This should be a fair process, and I believe it is a fair process, because the PP is also will also be given an opportunity to take the stand, even though I cannot confirm how many days will she be on the stand. She will be given an opportunity to take the stand, whereas members of this committee, we will be able to ask questions to her, and also for her to respond to this to the question. And also, it is a fair process because the PP, Advocate Mkhwebane, is also represented in this committee by her legal team. What we must guard against, Honorable Chair, is the throwing in of insults. That cannot be tolerated. I think for us to conduct a fair process, respect is what must also be our key issue. The respect should be given to all of us as members of Parliament, to the evidence leaders, to the witnesses, to everyone who's involved in this process. So we cannot hurl insult when we can't get our own way. And we want the chairperson to be firm also on things that are not right. This is a committee of Parliament. We want the driver of this committee to be more empowered, so that when an intervention is made, that decision of the chairperson must be taken into account. And also, we cannot allow this process to be derailed. We are not in a hurry to take decisions, but we have also time frames as this committee that we must finish our work. So delaying tactics cannot be tolerated in this committee, and also we cannot allow this process to be derailed. So thank you very much, Honorable Chairperson. I think I agree with the other sentiments as alluded to by my colleagues. Thank you very much.
Thank you, Honorable Dlabode. I now recognize Honorable Zungula.
Thank you, Chair. Greetings to yourself, the honorable members and everyone that is joining this meeting. I think, Chair, we need to remind ourselves that this is an inquiry to determine the fitness. It's not a prosecution. So I think that with that in mind, the direction of the hearings will be somewhat balanced, because when you inquire, you are going to have both the positive and the negative. Therefore, there needs to be fairness from the side, firstly, from the evidence leaders. So I would be very interested, Chair, to find out the list of witnesses that are brought by the evidence leaders, or that the evidence leaders intend on bringing. Because if the evidence leaders only supply witnesses that would be perhaps viewed as only having negative views towards the public protector, and there are no witnesses that are positive towards the public protector, then that would spell that it is not a fair process from the side of the evidence leaders. The second thing, Chair, is that you yourself must be balanced and you must be fair towards everyone, from the honorable members, evidence leaders, and the PP's legal representative. Now, you'll pick up from time to time the exchanges between yourself and Advocate Mpofu. And it goes with what one of the honorable members spoke about, that there needs to be a back room where you could iron out some of the issues instead of those issues coming out on play in the public. You'll recall, Chair, there are times whereby members of the committee make silly insinuations against Advocate Mpofu. I remember when he spoke about he's going to contribute to the process, so he intends on calling certain witnesses. One honorable member said it seems as if he's going to be playing a delay tactic and is going to stall the process. Something, in my view, that was uncalled for. And it showed that that member is somewhat biased towards the public protector and Advocate Mpofu. So if there was fairness from your side, you would deal with such, snide remarks that, erode the confidence that the public ought to have that this indeed will be a fair process. Then the last thing, Chair, is that the cross-examination will not be a sweetheart process. It will not be a process whereby people are going to be happy with it. It's going to be sweet. Difficult questions need to be asked, and difficult questions need to be answered as well. Perhaps the first thing that should be done when we come back, maybe is to get an expert on cross-examination, maybe to unpack to the committee what is cross-examination, what is legally permissible and what is not legally permissible in the cross-examination, so that we do not, when we are feeling, when you have certain feelings towards a certain witness, we say the cross-examination was harsh, whereas difficult questions need to be asked. So that is my proposal, Chair, that maybe when we start next week, let's have someone, an expert that will aid the honorable members, because we're not all lawyers, we're not coming from that legal field, so we might not be exposed to cross-examination, what is allowed and what is not allowed. So we can't say some of the questions in the cross-examination were harsh based on our feelings. This should not be about feelings. This should be about the legal processes that the committee needs to follow in order to achieve a fair outcome, and the process needs to be fair as well. Thank you.
Thank you, Honorable Zungula. Honorable Sposana.
Thank you very much, Honorable Chair, and greetings to yourselves, honorable members, and everyone in the meeting. Yeah, no, Chairperson, I want to agree with you. I think I couldn't have said it better in terms of your interpretation of double jeopardy. I think you are 100% correct. And I think as honorable members of this committee, I think we should all have the same understanding in relation to that particular matter. The second issue, the issue of the program, I also want to agree with you and also agree with Honorable Dagute that this program, it's a living document, and I think we should leave it. I want to propose that we leave it with you and the Secretariat to look at it if there's a need for perhaps to make amendments in order to try and recover some of the days that we have lost because of this break that we have taken. I think we need to look at it if there's a need for that, and then you make such amendment so that we were able to do our work and finish our work. The third point, Honorable Chair, that I want to speak on is the issue of your directives that you have issued to this committee. I think, yes, we are all aware that you have issued directives in terms of the National Assembly Rules 183. And I think we also know that it is your prerogative, I think, to issue such rules to the committee. However, Chair, I want to appeal to yourself, perhaps to look at Rule 5.9. The rule that says that a member of the committee, either directly or through the evidence leaders, may ask Advocate Mkhwebane directly to respond to certain questions posed orally or in writing, including factual disputes that may arise, even if she is not at the time giving evidence. And it further says, Advocate Mkhwebane must respond to such questions immediately unless she requests a reasonable period of time within which to submit a response, in which case the chairperson shall determine that reasonable time frame, etc. But I want to just pause here. Chair, I want to propose to yourself that for proper coordination of our work and for the proper flow of information and to perhaps avoid the disjuncture, I want to propose that if we've got witnesses that appear, that takes a stance before the committee, let us as members for that particular period raise questions that are directed to those particular witnesses. And if there are questions that we may have to the PP that emanates from the evidence of a particular witnesses, I would propose that let us reserve those questions up to such time that the PP takes a stand. And when the PP takes a stand, we are given an opportunity not only to ask questions from the evidence that she shall have put before the committee, but ask questions, even the question that emanates from other witnesses that shall have already appeared before the committee. I think that will assist us to have a proper coordination and avoid a disjunction, because I've seen, I think over the past days, that you would have a witness appearing, and then when we've got an opportunity, for instance, to ask questions to that particular witness, well, other members will choose to ask questions to the PP, of which in terms of the directives, they are correct. But it creates sort of a disjuncture in my view that we are focusing on this particular witness, but then there are questions that go to the PP. And we might sometimes perhaps lose an opportunity to ask questions to a witness, because a witness, other witnesses, they are only there for 2 days or 3 days. From there, I think you release them. But the PP is going to be with us up to the end. So is it not better for us to focus on the witness that is on the stand make sure that we ask all questions that we have, that because before the witness is recused from the committee, then these other questions we bank them because we know the people will be with us up until the end. When at the time when the PP takes the stands, then any question that relates to the PP is then that we are given an opportunity to ask, so that there's a proper coordination and there's no disjunction. I know it's up to you, Chair. I think it's your own call, it's your own prerogative, as the National Assembly rule says. But I want to make that proposals to you, just for us to have a proper coordination. Thank you very much, Chair.
Thank you, Honorable Skosana. The last few heads, I just want to check for this round. Honorable Heron, is that a new hand or a legacy hand?
Chairperson, it's a new hand. I just wanted to pick up something from one of the other members when I get the opportunity.
Okay, I will note you, followed by Honorable Siabe, Honorable Ngosi, and then Honorable Maneli. Go ahead, Honorable Heron.
So, Chair, I just wanted to, in response to Honorable Suka's concern that witnesses are not represented by legal or do not have legal representatives, I think there's two things I wanted to say. I mean, first of all, these witnesses, we've had three witnesses. One provided an affidavit in response to the call for public participation in this process. One provided an affidavit as a protected, so-called, let's call it a so-called protected disclosure, so we don't predetermine what it is, in 2019, but appeared under subpoena. I looked at our terms of reference. The terms of reference make it very clear that cross-examination is anticipated and provided for. So concerns around cross-examination are already in the terms of reference. But there's nothing in the terms of reference that says that someone who appears before the committee, perhaps under protest or reluctantly, is entitled to be represented. And maybe that's an omission in the terms of reference, that someone who may regard as Honorable Suka's put it, that they can self-incriminate or they could cause themselves harm by participating. Perhaps the terms of reference should have allowed for those who appear under subpoena to be assisted. Thank you.
Thank you, Honorable Heron. Honorable Siabi.
Thank you, Chair. And, good morning to you and honorable members. Maybe firstly, let me request, Chair, I have a challenge of connectivity. I'll switch my video off, if you agree.
I agree, Honorable Siabe, so that you can proceed properly. Just not, this is not for you. Just to indicate this point, I think in the management team with the IT, I would have been well briefed and were empowered that it's proper that members, at least when they start, they show their face. But sometimes members would say, I have a network problem. So I've been now schooled to just check on my laptop with that name. So there are signs when I would know when you have a network problem. I would know when you don't have. So it is not to you, it is referring to all other members. But continue and switch off your video.
Thank you, Chair. My view, Chair, is that up to so far, I think we've done well. And I want to thank you, Chairperson, especially the way you direct the process, taking into consideration that we are all human beings. And sometimes we have feelings, but still you were able to direct it in a manner that is seen to be fair. And I want to agree with the honorable members who are really emphasizing that we must do all in our power to make sure that the process is fair and is seen to be fair. But as we do that, because we are honorable members in Parliament, we must do so with respect so that the process can be seen to be a dignified process which can stand the test of time. And I agree that this is the first test for the South African Parliament. And whatever we do will always be referred to as this committee. Those who are coming after us, if they are to engage in this kind of a process, they'll refer to what we shall have done in this process. So we try by all means to be fair to everybody who's engaged in this process so that we can continue having the interest of the public into this process. And they say, indeed, this was a fair process. It doesn't mean everybody will be satisfied with it, but at least it must be to be fair. And Chair, having said that, I want to agree with the proposal on Directive 5.9. I think Honorable Skosana clarified it very well in support of Honorable Herren. Let me not spoil it. I want to agree that it is within your purview that you are able to look at it and will get direction from you. Because maybe what I can add is that sometimes we are tempted as members of Parliament in this committee to interject, and that also contributes to the delay of the process. And sometimes we are even responding to each other as members of the committee. It really causes to the delay. We are not saying we must be in a hurry, but we must not as well delay unnecessarily. Of course, depending on how far we go, we will be directed by the chairperson to look at the program. We said even from the beginning that is a living program. And where I'm standing, Chair, we are interacting with the public protector. And any other thing else to me, I might be wrong, but any other thing to me is not relevant. We are interacting with the public protector, and we must be seen to be conducting a fair process to her, in as much as it must be a fair process to the public out there. I think one member put it clearly that it must be a fair process to the public out there. And this one you can guide, Chair. My understanding is that witnesses are brought by the evidence leader or are brought by the evidence leader in consultation with the public protector. I'm not sure. But I'm saying they are brought by the evidence leader after having gone through some processes. And I take the evidence leader must take pains to protect her witnesses. It's her in this case, because he's a woman. But I stand to be guided, but I just take it because I'm not learned in that area. I just take that the evidence leader, because she's the one who's bringing these leaders, while the environment must try by all means to protect everybody who's participating in this process. But specifically when is an evidence that is brought by the evidence leader, I take she must try by all means to protect the witness so that we're able to get more information out of that witness. But I stand to be guided. But like I said, Chair, up to so far, according to my assessment, I think we've been doing well. When you start, yes, we might have been slow, but I think now we're on the right track. Thank you, Chair.
Thank you very much, Honorable Siabe. As I move to the next hands, just before I recognized you, just to indicate, I think there's quite a number of issues that have been raised. almost everybody. I think the issue of 5.9 has been canvassed. In the main, there's a suggestion for either enforcing that or re-looking at that particular issue. There's, I think, issues of relevance have been raised, fairness, as well as the not impugning character of witnesses, 6.2, 6.3, and 6.4. I think you've been dealing with some of those issues. There would have been an issue raised, and I'm raising this because when we go to the correspondence kind of intersects with our discussion now, and so it seems that we're covering that ground even before we hear from Ms. Fatima Ibrahim. So I want the following speakers to also respond. There's been an issue raised about this narrow and a broad approach, and Honorable Heron suggesting that we need to stay on the narrow lane, and that would be around issues that would not have come out of the panel in terms of concrete issues where I think the Baloy matter is made as an example in that regard, where there would not have been a particular pronouncement on it. So, Honorable Nkosi.
Thank you, Chairperson. I would request that I don't connect my video.
Okay.
Thank you, Chair. I think there are several issues that have been raised. Firstly, Chair, is that we must conceive of the committee as a committee of parliament, which it is. And therefore, generally, the rules of the National Assembly apply to the committee throughout its engagements with whoever. And in that regard, Chair, I think the following. Firstly, that we are used to, and we do question people who come to committee and become very robust and rigorous in all instances and require specific answers from people that account to various committees. So for me, it is no different. It is the same as we do in the committees. The only difference here is that we are engaged in an impeachment process. And therefore the relevance of cross-examination, which makes it slightly different from the general rules applicable, but not substantially different. Therefore, in cross-examination, I think we don't need an expert to really come to school us on this. What we need is that, as is done elsewhere, that we should observe the general principles or etiquettes involved in cross-examining somebody seeking to have concrete answers to issues before yourselves. Common courtesy, even if you attack the character of a particular witness, you do so within confines of deference to their points of view, and also extending to them and making them very comfortable that you are not badgering them unnecessarily. So robustness and incisive questions that seek clarity on particular issues should not degenerate to badgering a person or a witness, or to demeaning their personality, their dignity, which are guaranteed in the Constitution. So I think all what we're saying is that in line with principles of fairness to a person, it's important that those that question, including ourselves, but in particular the representatives of either the witnesses or the public protector herself, should not debase people. You can comment on character of people as it's acceptable, but you cannot debase people by attacking their dignity and undermining their rights, even in the process itself. The second point relates to what we have experienced so far, and I think that we are on course, and I agree with all members that have expressed the same. We are on course. What we need to do is to realize that as a committee, the evidence leaders present people to us, and we have a responsibility to probe and probe deeper on issues that the affidavits disposed elicit, and therefore we should be careful not to be overwhelmed or rather to overreach ourselves. These are people that have deposed of affidavits. We confine ourselves to what is in the affidavits of those people, and extraneous on that, we concentrate on what is contained in the panels, the review panels report. That brings me to the third issue on what approach to take, whether we take the narrow or the wider approach. I think our terms of references quite specifically indicate what we should do and what is expected of the committee. And out of that, the chair has issued directives based on section 1A3. While it is tempting to really get into this technical issue or legalese on whether it's a narrow or wider approach, I think we should base what we do on what our terms of reference say and what the directives from time to time indicate or expect of us to do. So choosing either a narrow or a wider approach may not necessarily answer what we are about, but I think to a large extent we do know in terms of the terms of reference and the directives by the chair what to ask and what not to ask. It is upon the chair to then determine what is relevant for a particular issue or what is not relevant, and the chair is empowered to do so as it happens in committees. So we shouldn't complicate it. We shouldn't put ourselves in a position of being legal representatives or lawyers. We are not that. We are members of parliament who are conducting an inquiry to establish the veracity of or determine whether there is competence or incompetence, etc., and misconduct. Lastly, Chair, in response to the issues that you have raised when you opened the meeting, I agree entirely with people who have made comments on the issue of double jeopardy. But I think it needs re-emphasis, Chair, to go back to what Advocate Bauer did when she opened the proceedings, that this is not a court of law. It's neither. It is the quasi judicial process, and it is just an inquiry that is done by Parliament, and that we should through you guard against bringing issues that are extraneous or that do not necessarily address what we are about. And in that regard, I think so far we have done very well, and I think we should appreciate the fact that you are in a position where you direct us, and our responsibility is to offer both support to yourself and ensure that in executing your responsibility, you ensure impartiality throughout the process. And that's why you are the chair of the committee, and we are members of the committee. Thanks, Chairperson.
Thank you, Honorable Bosi. Honorable Luzipo.
Thank you, Chair. I'm sure now you see my face. So even if I switch off the video, yes, thank you. I might be in a wrong place. for the committee. Thank you, Chair. Just very quickly, I must say that I concur, General, and greetings to colleagues and those present in the meeting. First, I must say I agree with most of the proposals or recommendations that are being made. First, I think let's agree that part of the directives would say all of us who are participants in the process must also recognize the fact that there is a chairperson and we must speak through the chairperson. In the event we are not satisfied with how the chairperson is reacting or responding to us, I think there are mechanisms that are created through the parliamentary rules and procedures that we can handle that. I'm saying this, Chair, because we're not handling a matter of our own. We're handling a matter that is a matter of national interest, and we have and we need to respect that. Beyond respecting ourselves, we also need to respect the privilege that people are supposed and are looking up to us, that we must do what is in the best interest of the nation. I think that is the first thing that one wants to make. The second thing I just want to say, Chair, yes, I agree again that we must stick and be clear what is the responsibility that we are having, and therefore stick to what we are supposed to be doing fact-finding on in relation to the allegations, so that we don't risk going around on other matters that may not necessarily be relevant on what is the basis of the existence of the committee. Very quickly, I think one of the things for me I think are quite critical is that is what members were saying, and I know it as we have said, you have got 2 or almost 3 combined systems, a committee system and an inquiry system, but at times we would have said something that is closer to a disciplinary system. So it may be very awkward or difficult to find what suits. What should guide the process is the rules of fairness and equity. And in that process, I think for me, one, the evidence leaders have, in my view, have got a duty and a responsibility not to protect or defend the witness or stand, but to ensure that the process goes as it is envisaged, and therefore provide that required and necessary clarity, including on the relevancy and the manner in which those witnesses probably might be dealt with, but without protecting them. I hope that is clear. But also within that context, I think what honorable members were suggesting, in my view, that process will address the rules of fairness and equity. Because if you were to ask questions to the public protector in the midst of a witness that is on the stand, there is nothing that stops now that unintentionally the entire process is defocused to, because when I looked at, which is why I will agree also looking at the directive, the risk is that there is no limitation on the questions that I would say can come even before the public protector can be on the stand. So I agree 100% that maybe all of us, let's agree that we keep the questions that we have, we allow the process to go in, and then when we ask the public protector, we will still be within our own ambit of operation to ask the public protector at that given moment based on the evidence given by other witnesses. Lastly, Chair, I think also we should, in my view, be very careful or be very consistent on one issue. The point that honorable members have raised, relevancy. I'm saying relevancy, including at times the question of questioning bona fides, either from our side or even from the legal team of the public protector. Let's give this process its own chance. We have a recourse at the end of the day if there's something that has not gone through. The problem is that we may spend too much time dealing with issues of perception about each other. I think there is a manner to handle where we feel that procedurally, the manner in which issues are raised, they question the intentions and bona fides of those who are participating in the process. I wanted to place it there. Thank you very much.
Thank you, Honorable Zippo. Is that a new hand, Honorable Dlagude, or legacy hand?
Honorable Chair,
Yes.
I want to clarify something which I forget to deal with when I was on the podium, when I was on the floor.
It's fine. I'm going to invite you and then followed by Honorable Nola, Honorable Melda, Honorable Olomisa, and lastly, Honorable Maneli.
Thank you very much, Honorable Chairperson. I think there is one member who said, as this committee, we are dealing with a political party motion. As much as the motion was brought in by the DA, but Rule 88 of the National Assembly rules allows for that. It says, if you allow me to read it, Honorable Chair, it says no member may reflect upon the competence or integrity of a judge of a superior court, the holder of a public office in the state institution supporting a constitutional democracy referred to in section 194 of the Constitution, or any other holder of the office other than a member in the government whose removal from such office is dependent upon a decision of the House, except upon a separate substantive motion in the House presenting clearly formulated and properly substantiated charges, which, if true, would, in the opinion of the Speaker, prima facie warrant such a decision. What I'm trying to clarify here, Honorable Chair, is that the trigger to the establishment of this committee was based on this Rule 88, because there were accusations that were made on the holder of the office of the public protector. And for this to be dealt with by Parliament, it needed a substantive motion, of which the member of the DA submitted to the House. Hence, there was this independent panel which dealt with the issues to check if there was a prima facie evidence or not. Hence, we are here today as the Section 194 committee. So I wanted that to be clear to everyone that we are dealing with something that is allowed within our rules of the House. Thank you very much, Chair.
Thank you, Honorable Lagude. I now recognize Honorable Paul Angola.
Thank you very much, Chairperson. I think my colleague.
You are audible.
I think my colleagues did cover a lot of ground in terms of what ought to be dealt with in this meeting. I want to echo the views of other members that in terms of the process, we are still doing fine. Of course, we have said on the 11th of July that these are uncharted waters. It is the first of its kind. We all considered to the fact that we are going to receive some lessons as time goes. Some of the matters ought to be dealt with and attended to as they come. Hence, even the directives are actually, Chair, trying to assist us to deal with the proceedings. I think, Chair, we have, since the resumption of this committee, not the hearing per se, since we first met as the committee, all agreed in the nature of the proceedings we're dealing with here. In that we have all considered that they are neither judicial nor even quasi-judicial. So I think we'll be overstepping too much. It would, if we would go to an extent wanting to call expert legal people to workshop us on cross-examination and all those things. And I agree with the sentiments of other members that it would actually be complicating this which we are supposed to be dealing with. And equally, it will affect what is raised in the Rule 89 and the Rule 129 AD of the Rules of the National Assembly, that we must impartially and deal with this matter within a reasonable time. So if you want to bring a lot of what we call expert opinions into the inquiry, it will actually impede within the reasonable time a kind of the way. Lastly, Chair, I think I'm not sure if I am in the right meeting. I think we are dealing with a motion that was lodged or filed by Honorable Mazzoni, who is in her capacity as a member of Parliament, protected by the 9th edition of the Rules of the National Assembly. I haven't seen, since we've started a letter with the DA logo, since we have resumed, what has been submitted, Chair, even in the independent panel for it to find the prima facie case, was submitted by a complainant, by the Member of Parliament, Honorable Mazzoni, not a Democratic Alliance. I do not think that, Chair, the Democratic Alliance is party to these proceedings as per the information that we have already received. So, Chair, I want to commend ourselves that at least we're able to proceed with something that we have never been exposed to before. All of us across political parties, the evidence leader, Chair, may have been part of commissions, but not this kind of a commission. So we must equally understand that even in her capacity as an advocate of the High Court of South Africa, this is her first experience dealing with such kind of a matter. Equally so, Chair Advocate Mbofu, representing the Public Protector, has actually considered that this is the first kind of proceeding. He has been practicing as an advocate of the High Court of South Africa for a number of years, but this is the first of its kind that he has to be exposed with. And Chair, we must equally say, we have all agreed in the first meeting of the hearings that there are going to be some issues that we'll have to deal with, and we are going to deal with it as the proceedings come. So I wish to submit that, Chair, and actually commend the manner in which honorable members are proceeding with this matter, and actually wish to say equally, Chair, let us continue showing resilience unto this matter. Let us continue showing fairness and impartiality in dealing with this matter. Of course, Chair, as time goes, as we collect various forms of evidence, then a direction will be able to sit at this committee and say, out of what we have received from witnesses and from everyone who testified in the committee, this is what we see. Then we'll therefore deliberate on that to that effect. Thank you very much, Chair.
Thank you, Honorable.
Recording in progress.
Honorable Mulder.
Thank you, Chairperson. My apology. I was distracted for a minute with a phone call, and if this has been discussed by the colleagues, my apology for that. I just want to make one point in terms of the process going forward. I am not sure that we can just accept as a fact that the Public Protector is going to testify in her own right in terms of, like other witnesses, which will allow cross-examination from the evidence leader or being directly asked questions from the members. I don't think we should just accept that that is going to happen. It could happen that at some stage, Advocate Mpofu informs the committee that the Public Protector decides not to testify, and that they continue in terms of the director that questions need to be put, and she will reply in writing. I'm just putting it there for us to take on board.
Thank you, Honorable Mulder. Honorable Olomisa.
Thank you, Chairman. Good morning to all. Mine is very, very, very short. I wish that the chairperson and the evidence leader would have time to scan and check the witnesses who are to appear in front of the committee, especially the witnesses who are still facing or challenging the disciplinary related issues which were done by the Public Protector's Office. Because if we are not careful, the chances are that we might be portrayed or viewed as if we are a court of parliament. Because some of the issues which they raise, they tend to look like it's an aggrieved person we are dealing with here. Both witnesses so far, yes, they have tried, but we have to be careful when we bring witnesses here. Have a policy where you bring credible witnesses. I'm not insinuating that they're not credible, but I had difficulty in both witnesses we have had. The one was part of the so-called rogue element. You could see that there are gray areas. And also on this one, he says, no, I cannot answer you because I still have a court pending case in court. So we must be careful. That's all. Thank you.
Thank you, Honorable Minister. Honorable Maneli.
Well, thank you, Honorable Chair. In case I do get again the connectivity challenges, please allow me to switch off the video, but I'll continue this point. Thanks, Chair. Of course, I'm coming at a point when you've already made some remarks to try and direct beyond that point on what we could also look at. And therefore, would start by saying, I agree with the initial remarks that you would have made, as well as how members would have reacted to that. But I just thought to just emphasize a point on the 5.9, just for purposes of you helping us to steer the inquiry properly, is that because the directives were issued, and from time to time there will be reference to that, and that I take it that the concrete proposal on the table, given what the rules allow you to do, which I must say, we should also commend you for being democratic on this matter of the directives, because it is a matter you should be able to deal with as the chair. I think we should commend you on that. But that it's the proposal on the table, it's really to reconsider that point so that when you reissue directives, it's understood that in canvassing this matter, the committee has a sense of agreement on that, to also help the flow of the sessions that we are having. I think reasons have been given by members on how, if we continue in the way we were doing, can even slow or even make our points irrelevant later on. So I thought it should be at least concretized. The other point, Chair, relates to what you called the broad and the narrow approach. I would take it that indeed Honorable Nkosi covered me on this point, that necessarily we are dealing with evidence put before us, and in this instance, these are witnesses who would have taken oath in terms of what they are putting before us. And of course, sometimes the information presented to us will be quite wide, but we still have the responsibility, even ourselves, as we ask questions, that we would remember 3.1, 3.2, which talks to what exactly do we seek to get out of that. But of course, Chair, I really sympathize with you sitting in that position, that you would not be able to censor what could come out of any member. I think it's on the basis of presentation that you'll be able to say whether there's relevance or no relevance. And I'm in writing on that because it's linked to the directives. In writing on that, it's the issue, Chair, about matters that you have ruled upon. I think we need to get a sense as the committee, especially because, like Honorable Ngola would have re-emphasized, we are really in a space of uncharted waters. So as you make these rulings, I think it may just be important, maybe working with your legal team, to just help members, which is ourselves, to reflect on those rulings so that, again, we do not get this point where everything else is between the chair and the legal representation or the public protector side. But as the committee, as part of defending the work of the chair, is also to really remind ourselves from time to time that at least this matter would have been ruled upon, and we should be able to move from that, because sometimes we spend more time on matters that would have been ruled upon. So I'm asking, Chair, respectfully, that if we can have that, at least for members to know, as we'll be getting to other witnesses going forward, that matter is dealt with. I think the other point really to make, Chair, is that I think it's too early at this point to even believe that you may have not acted fairly, even in making interventions. And I think Honorable Lucy put it, I think, for me nicely, that necessarily your role is not to protect what is being asked or not asked, but clearly from the directive side of things, I think the sensitivity will be when there's an attack on the persons to a point of infringing on rights and dignity of people. But in terms of what is put before the committee, which will in the main be from affidavits that people have taken oath on, we may not be really asking questions in the same way. And as I say, Chair, it may look like you are biased on this or not biased on that, because again, you're also struggling with the fairness aspect of it. That if you interject all the time to try and make some rulings, it can also be construed like dislodging a speaker on the platform in terms of logical flow of what the questions that the member would have raised. I would have not completed my point, Chair, if I do not really, I think, get back to this point, which I think Honorable Ngola has quoted it from the rules. I'm just saying, even outside of the rules, because it also talks to a question we ourselves would have posed about one witness, where you would not look at the person and the integrity of that person, but look at the political affiliation. So we have dealt with that matter in one of the investigators that were mentioned in the evidence that has been put before us. So I'm just saying it's important that it's understood we are acting in the best interest of the public, because we're also dealing with the public protector in this case. And therefore, political affiliation it's a matter that really doesn't arise. And I'm just saying it's one of the rulings you have made, that you've clarified why this committee would have been put up. So we're no longer with whether Honorable Mazono or what. The directives are directing us that we are looking at misconduct and incompetence if it exists, and we test the evidence that's before us. I think, Chair.
Thank you, Honorable Maneli. The very last hand, Honorable Manketsi Klape.
Thank you, Chair, and greetings to the members of the committee. Chair, let me also indicate that I support the proposal that has been brought by Honorable Skhosana on the matter that we hold back a bit on questions to the public protector. We note whatever we want to ask so that we are structured at the end of the day, and we would be able to follow up on questions that members has asked. If we become erratic, I'm afraid that some matters might fall into cracks. So that will be the first point. Chair, I also believe that like in all other committees, when a motion has been adopted in Parliament, in the National Assembly, in the House, it moves from the person who sponsored and it becomes a National Assembly's matter. And thus, the formulation or the establishment of this committee coming from the House has to deal with it, and we wouldn't take it back to the sponsor or even the political party. Chair, it is also my belief that we allow, as we agreed when we started, allow the evidence leaders to sift the witness, of course, on a balancing scale, as one member has suggested. But we would not know, or you will not know as the chairperson, how to deal with such. I heard yesterday, for an example, Tate Kekana saying he has consulted with the evidence leader on a day or 2 days. So it will be proper that we allow the issue of the witness to be handled by evidence leaders instead of bringing it to the chair, in as much as we would want to say how we could deal with other issues. I think them being legal people, they are better placed to deal, and it is their competency as such. On my reflections, Chair, how things has been, I think I must commend the members of this committee in balancing the purpose of this committee to say we are not a committee that is judging. We are here to find facts and gather empirical evidence on the matter that has been put before us. And Chair, also commend you how you run this meeting. You know, I was looking at how issues sometimes become heated. It might not be an insult in legal terms to say certain words, and others are not written anywhere. They come out of Ubuntu, how you deal or how you talk to people. But we must also not fall into a prey or play into the gallery that you have been doing, that you maintain your calmness, you maintain your cool when such matters arise. And we have been doing a great job in that regard, because sometimes where one is seated, you feel provoked, but you have been able to handle the situation. And in that regard, Chair, I would plead also with members like others are saying, let's allow you space as the chair to steer the ship. Because at times we might not know, Tina, where we are sitting, or what is the motive? Do we want to collapse the meeting at that point or what? So as the chair, I think you have been able to carry us out of such problems. So I think we are okay at the moment, and believe that it was proper that we set our directives, our terms of reference, our living documents, and they will navigate us as and when we go through. So it is up to the chair as we make proposal. based on these documents being living documents, to amend as necessary so that at the end of the day, we're able to reach the intentioned destination with this committee. Thank you, Chair.
Thank you very much, Honorable Manketsi Klape. That was the last hand. You had 19 members speaking today, which is the majority of this committee, with Honorable Dlakude, Honorable Herren, Honorable Melder doing a double dipping in that process. I'm sure that's part of fairness. Perhaps before we summarize and step off from here, just to recognize the legal advisor of this committee, if there's one or two issues you want to pick up and deposit here, Fatima, I will allow you that opportunity.
Thank you very much, Chair. I just wanted to alert the committee to the letter that Advocate Mpofu had indicated during the course of the day on the 18th of July that he intended sending to the committee. That was indeed done sometime toward the late afternoon. Chair, we are in the process of preparing a response, but I'll take the committee very briefly through some of the issues. The first, Chair, is the argument that Advocate Mpofu had raised during the hearings that they are of the view that this committee is not a removal committee, as he called it. I think that there was an attempt to argue that what this committee is doing is preemptory in some manner, and following this process, there should be another process before the House eventually determines the question of removal or not. And of course, Chair, that is not our understanding. It is not supported by the way in which the rules are crafted, and it's certainly not supported by any of the outcomes in the litigation processes to date. Chair, much of what is raised in the letter has been canvassed in court already. It's a rehashing of some of those issues, but nonetheless, when we do respond to the letter, we will touch on everything that has been raised. The next thing that is raised, Chair, is that the continuation of the sitting breaches our duty of fairness. We have maintained on this point from the very beginning that in the absence of an interdict, the committee is free to proceed. And in fact, Chair, in accordance with Section 237 of the Constitution, this committee is bound and Parliament is bound to perform its duties diligently and without delay. So until a court rules otherwise, we have advised that the process can continue. Chair, there was an issue then also raised in relation to the public protector being denied access to materials and persons necessary to exercise her right to defend herself. And the committee has resolved to continue as if nothing of such significance has indeed occurred. Chair, it has been our understanding that the Office of the Public Protector and the DPP in particular has offered support. That's the information that is before us. We understood Advocate Mpofu to say that the access to the emails have been restored and that there was a mishap of some sort. And also, Chair, Advocate Mkwabani is being fully legally represented as per the court ruling in the Constitutional Court. And so we intend to reply as such. If she is having difficulty in securing the presence of any particular persons, we did build into the directives that she may approach the committee to summons such persons. That would be done in accordance with the Powers and Privileges Act. So it's not a right that immediately once a request is made that the committee is therefore forced to accede to the request, but rather that the committee will consider that on a case-by-case basis. And if the committee feels it's necessary for that witness to be subpoenaed, then certainly the committee will resolve in that manner. The letter also raises the issue of the, I'll say, the so-called illegal suspension of the PP. Chair, as we've always indicated, that was a prerogative of the president. There is an allegation here that that taints our processes, and our process is now illegal because of that suspension. But regardless of whether a suspension had happened or not, had the president chosen not to suspend, this process would have still continued. But of course, the emphasis there is on the fact that the speaker had addressed a letter to the president informing the president of the continuation of our processes, and that followed the Constitutional Court ruling, which in terms of which we were allowed to proceed. Chair, that is going to be dealt with and argued in the High Court next week in Part B of the application. Therefore, our conclusion on that was that the legal validity of our proceedings are not dependent on the legal validity of the suspension. It is in fact a separate issue in law. Chair, they further raise an issue in respect of Honourable Milam and his marriage to Ms. Mazzoni. Our office has prepared a legal opinion on that matter because in fact it was raised by the EFF in a separate correspondence sent to the speaker, and so we have prepared a legal opinion which, as I understand, will be dispatched to the Secretary of the National Assembly sometime this morning that deals with that particular issue. They also raise an issue that no persons from the DA should be on the committee because of the fact that a member of the DA was the person that submitted the motion. And Chair, we disagree. We disagree with that. It's unexceptional that political parties represented in the NA and their representatives would express strong views on any matter. In this matter, there are parties that have expressed strong views for the removal and against the removal of the PP. But the point remains is that this process, members need to apply their mind rationally to the facts and the evidence read against the rules in order to find whether the PP has indeed misconducted herself or is incompetent as alleged. So it is not a policy choice that is being made here where regardless of how the committee proceeds, there wouldn't be neither choice would be unlawful, as it were. If a committee were to be deciding whether a public holiday should be held or not held on a particular day, there's nothing lawful or unlawful in that. That would be a policy matter. But in this particular case, a finding can only be reached with due regards to the definitions of those terms as they appear in the rules and regard to all of the evidence before the committee. Chair, in any event, we also submit that members can't approach this inquiry with a closed mind. And I think that the evidence leader had gone into some depth on that particular issue, and that members must, in line with their oath and affirmation, perform their functions and discharge their functions in a fair and a reasonable manner without any regard to party political interests. Chairperson, then there is an allegation that the chair has been biased in the conduct of the proceedings thus far, and there are some general examples that have been given. The content team has gone back to look into the record to try and pick out specific incidences, and we will respond to those in more detail. Chair, you've dealt with the double jeopardy rule, which has also been raised, and the rest then, Chair, are all other issues that we will attend to. There was also an allegation that the directives were not fair and that we rejected all the submissions made by Advocate Mpofu and his team. Chair, that is an inaccurate representation. In fact, there were directives that we agreed on, and there were certain things that we didn't agree on. One of the pressing issues being the narrowing of the motion. I did advise when this matter was first discussed that we were of the view that this committee doesn't have the power to narrow a motion that's been referred to it in full by the National Assembly. and I gave my reasons for that. I won't repeat that now. Chair, I think that about covers it. As I said, we will prepare a comprehensive response, and we will share that with the committee chair once you have considered it and signed it. The other last matter that they raised was simply to ask that the committee not sit next week, Wednesday. We had agreed that the committee will not sit on Monday and Tuesday as part B of the hearings are going to be held in the High Court. Advocate Mpofu indicated yesterday that they have asked that those hearings be extended to Wednesday. Our counsel has informed us that that letter was only received late yesterday afternoon, and that it's unlikely that that in fact will be the case. But Chair, as I understand you, we will go back and work on the program members having agreed that there will be some flexibility in that regard. That's all from my side, Chair, unless you want me to respond to any of the matters raised by members in particular. Thank you.
If there's anything you want to take out or respond to, please do so.
Chair, no, I think I'm covered. I've appreciated everything that members have said. Chair, this issue, which I can see is cropping up quite a bit in the respect of asking the PP questions as and when we go along. That, in fact, Chair, was built into the directives because it comes out of the Constitutional Court judgment that dealt with the rules. That judgment in February, the court made it clear that the legal representative of the PP cannot give evidence on her behalf. And the fact that the office bearer is entitled to legal representation does not imply that she cannot, that the committee cannot ask the office bearer to respond to certain questions, even if she is not at that stage giving evidence under oath. Chair, I think that there is agreement amongst members that they are going to try not to ask those questions in a manner that's going to delay processes, but certainly members have a legal right to ask questions if those questions are necessary to be asked at that time, especially when it comes to issues of clarity, by way of example. The other day, I know there was an issue as to whether the voice on the recording was in fact the voice of the PP, and members wanted some confirmation of that. Things like that can certainly be answered immediately. At the end of the day, Chair, this is an oversight process. So we must be mindful of that, even though it's a sui generis process in that it's not an adversarial process, it's not a court process, it's something unique within the parliamentary structure, but at its heart, it is still an oversight process. Chair, that's all from my side. I do have the Chief Legal Advisor on the platform, and Advocate Frankie Jenkins are also on the platform. I'm not sure if they want to add anything further, but otherwise we are happy to respond to specific questions if the members have anything that they would like us to address.
Are they here? Anything else they want to add?
Chair, I don't have anything to add. Thank you very much.
Okay, Zoreya?
Yeah, thank you very much, Chairperson. I'm really humbled by Ms. Ibrahim's grasp on the issues before this committee, and I'm happy that she has covered everything, and her commitment to the process is absolutely confirmed by this. But just to add one small point, and that is in respect of both the conflict issue as well as the double jeopardy issue. Those were two of the 12 issues that were canvassed by the public protector in the litigation. And from our side, it has been settled by the Western Cape High Court in the judgment of Bartman and others, as well as by the Constitutional Court. So we have settled law in that regards. And as Ms. Ibrahim has indicated, we can share the opinion which we are settling on the question of conflict of interest during the course of the day. Thank you, Chair.
Thank you, Ms. Adhikari. Thank you very much, Ms. Ibrahim and Mr. Jenkins on that. That was just a brief summary of the correspondence, taking you through all the key issues there, and a brief comment on what members would have been engaged on. I see two hands. It will be quick comments this time. I would not be going for another marathon. Honorable Hendricks, followed by Honorable Aaron.
Thank you very much, Honorable Chair. Honorable Chair, I agree with the opinion of our three legal eagles of Parliament that nothing must prevent us from continuing the hearing, whether this President suspended or not suspended the Public Protector. However, I don't agree with them, with all respect, because I'm guided by the Zondo Commission, which says that Parliament has failed to do proper oversight. So we also have to do proper oversight if the President suspends or doesn't suspend. And so while I accept it's two different entities making a decision, Parliament and this committee has to do oversight on the suspension if it wants to. The legal team mustn't hamper us. Thank you very much.
Thank you, Honorable Hendricks. That was quick and precise. Honorable Aaron.
Thank you, Chair. I just want to pick up on Ms. Ibrahim's comment about the narrowing of the inquiry, and to ask. I don't really understand her comment that the committee cannot call. Well, the suggestion that not calling some of the witnesses or to support some of the charges would be narrowing the inquiry. As far as I understand it, there are 4 charges, and that all of the evidence that's been called is being called in support of those charges. If the independent panel found that some of the evidence does not support the charges, why would we still call those witnesses? And how does it narrow the motion or change the motion? The motion is still the 4 charges of misconduct and incompetence. But for example, the Beloyi matter, the independent panel found that there's no prima facie evidence. And so what value would that add to us hearing it?
Okay, thank you, Mr. Herren. Any other member who wants to comment on what the legal advisor and the team put forward? Before I ask you to quickly respond to that issue? None. Thank you, members. Ms. Fatima Ibrahim, do you want to have a take on that?
Chairperson, evidence will be called in respect of all of the charges and sub-charges. Of course, where the independent panel did not find that there was prima facie evidence, and by way of example, charge 4 as it relates now to some of the names listed there, where it says that the PP is guilty of misconduct in respect of the intimidation, harassment, and victimization of staff. Chair, the threshold is going to be a little bit higher than what the threshold would be in cases or in relation to charges where the independent panel did indeed find that there was prima facie evidence. In those cases where there is prima facie evidence, even there, the committee would have to hear the evidence that is now being presented to it to see whether that evidence disputes that finding of the panel. Chair, we must be mindful of the fact that the mandate of the panel was narrow. It conducted a desktop exercise. It had no powers to call for oral hearings, and it was restricted to the evidence that the member included in support of the motion, whereas a committee of parliament has other powers. It has the powers to call people, to subpoena people. We will listen to oral evidence and so on. So certainly the fact that the member who puts forward the charges is not able perhaps to gather evidence should not mean that Parliament, who does have that power and those resources to do that, should not be doing that. But I certainly agree that the threshold is going to be slightly different, and the committee may find that they cannot sustain any findings in respect of those particular charges after having heard everything. But again, to reiterate, Chair, that would be the same even where there is a prima facie case. If not, it would serve no purpose for us being here. We now need to test that. So that was in fact just a first sifting mechanism, Chair. Thank you.
Thank you, Ms. Ibrahim. I hope that's helpful, Honorable Heron, even if you might not entirely agree with that.
Yeah, Chair, it's not that helpful and I don't agree with it, but I don't know what to do about that.
Okay. Okay, for both.
But Chair,
wait.
It's me. I just want to address Honorable Heron.
Okay.
Does it mean that the PP, if she wants to demonstrate that she was, I'm venturing into something very difficult, but let me say that procedurally, if the PP wants to adduce evidence that she is not competent, would she not be allowed to call a witness or to adduce evidence that in this instance, I acted quite impartially, fairly, and in terms of procedure? So if we say no, don't do it, because we want to exclude or to focus only narrowly on issues, then reciprocally it means that she cannot call that witness. I'm not sure if Honorable understand what I'm saying.
Yeah, maybe so that I avoid the dialogue. I see your hand, Honorable Heron. I think it might help to, as I go to you to comment, I think to take the point that Honorable Ngos would have raised before in that regard. And his point in essence was that perhaps it's important that we go through this process without us confining ourselves either way. So I think that for me is very key, because there's going to be debate about this in the sense that we would have different views about what needs to happen. So, Honorable Heron.
Chair, no, I'm not saying that the public protector can't call witnesses in her defense. What I'm saying is that charge 4 relates to misconduct and incompetence and relates to the intimidation and harassment and victimization of staff in general. And there are a number of witnesses or number of incidents that are submitted in support of that charge. The independent panel has found that in one instance that I can remember, the evidence does not reach the level of prima facie evidence. And as Ms. Ibrahim is saying, in our hearings, there's a higher level of proof that's required than prima facie. So why would we call a witness? There are other witnesses who support this charge that can be called, but why would we call a witness who's already been identified as unable to meet the standard of prima facie evidence? So I'm just, it's not about narrowing the motion. The motion still has 4 charges. It's about saying, do we call a witness as the committee when in the predetermination phase, they were found, the evidence is found not to reach the level of prima facie evidence?
Okay. I would request, unless Ms. Ibrahim, you want to come in, that perhaps the points are taken, because at this stage, we are not talking about a specific witness, and part of the homework that we'll do will also look into those issues, but we don't want to corridor ourselves in a danger that a few steps ahead, we realize that we would have closed the door on the particular work that we would have done simply by deciding that we want to agree to either this approach or not that approach. So I would request perhaps that we see how this process unfolds in this regard, unless Ms. Zoraya or Ms. Ibrahim, you have a comment on that.
Chair, I just wanted to say that in respect of the names that are listed, it may be that somebody is called in relation to a matter that does not deal with this issue of intimidation, harassment, or victimization of staff. So by way of example, Mr. Kikana's name also appears as 10.6 in the motion. Mr. Kikana was not called to deal with charge 4. Mr. Kekana was called primarily to deal with issues related to the Saab and the Theodore Dairy matter as canvassed in his disclosure made to the speaker. So the fact that a witness is being called from that list, I don't think that there should be an assumption that it's necessarily in relation to the intimidation, harassment, and victimization. There are other things that also fall under charge 4, where the independent panel did indeed make a finding of incompetence in particular that deals with capacity and resources of the staff, the failure to prevent fruitless and wasteful expenditure, and the manner in which investigations were conducted. So I just wanted to highlight that, Chair. Thank you.
Thank you, Ms. Ibrahim. Can we leave it there, colleagues? This particular point? Thank you. I think at this stage, to probably just to indicate, I think we've had a very fruitful and comprehensive discussions. You would have given us a lot of homework, myself as a chair and the team, including the evidence leaders, some work to do. And in that regard, that will be able to interact with the legal team of